just thinking January, court full of people.
Really?
I'm going to go back to in person. Won't have the jail transporting. So we'll have those will be still on Zoom, but anybody not in custody and the lawyers will be here. So how about them apples? I figure at some point we have to go back. We have to go back to the old way at some point. So might as well just get a start. And it is hard. You see it with lawyers. You see it with parties, and yeah, I mean, and it's civil and family and criminal.
Recall number 12, People versus Randall Hisler, 22582 FH.
All right. Today is the date and time set for sentencing in this matter. Mr. Hisler, can you hear us?
Yes, sir.
All right. I'm going to ask a series of questions. Most of them, Mr. Schemke is going to answer. You'll have an opportunity if you want to answer for yourself. Otherwise, I'll give you a final opportunity before I sentence you to speak to me. Okay?
Yes, sir.
All right. Have you had a full and complete opportunity to consult with Mr. Schemke before coming into this hearing for the sentencing today?
Yes, sir.
All right. And sir, when you were in court on October 19th, 2022, you pled guilty to assaulting or obstructing a police officer. And that is what we are here for today. And Mr. Schemke, that's correct, right?
Yes, sir.
Pled guilty to count one.
Yes, Judge.
All right. So I've had a chance to review the pre-sentence report. I've looked at probation's calculation of the sentencing guideline range. I'll certainly hear from Mr. Schemke and Ms. Blanche if there's any challenge to that. I've gone through with the information in the pre-sentence report and scored it myself. And so I'm prepared to go ahead. I'll take all the information that's presented as information and advice on the issue of the defendant's sentence. So based on the information in the pre-sentence report and statements on the record today, I do find that the sentencing guideline range 7 to 23 months is appropriate and supported by what's in the record. And I will sign the sentencing information report. Now let's go back to you, Ms. Blanche. Do we have a victim impact statement or any comment on the recommended sentence in this matter?
Yes, Your Honor. Agent Howard is here, and she'd like to make a statement to the court.
Okay. Agent Howard, please feel free to make that statement.
Hello, Your Honor. I prepared a written statement, so I didn't forget anything.
No, that's fine.
First, I'd like to thank the court for offering me the opportunity to speak on this matter. After 20 years working for the Michigan Department of Corrections as a parole and probation officer, this is the first time I've ever had to testify as a victim. This is the first time that I've ever had a supervised individual physically attack me. Every day I walk into work knowing that I worked a dangerous job. I come into contact and work closely with individuals from all walks of life who have led very, who have led lives very different than my own. However, working a job where I encounter dangerous people does not mean that I am not entitled to know that I will go home every night. I pride myself on a well-honed set of de-escalation skills and tactics and a positive rapport with the individuals I supervise and come into contact with. When Mr. Hisler attacked me on July 25th during a routine home call at a residence of one of my parolees at a home he had previously been warned about being at, he put me in jeopardy of not being able to go home to my family. No amount of de-escalation tactics could have been utilized on that date. Mr. Hisler and I have known each other for 2.5 years. He is supervised by another agent in my office, and that agent and I have often have our parolees meet us at the same field locations on the same days. Mr. Hisler has reported to me when his agent is off duty or homesick. Mr. Hisler knew that I was well aware he was a parole absconder and not being truthful when he told me he was that he was in compliance that day. As soon as he saw that I was not buying his story of being in compliance with parole, he was determined to escape. When Mr. Hisler approached me that day, I was on the phone with his agent. He came at me quickly and I had to drop my phone in order to protect myself. I gave Mr. Hisler multiple verbal commands to stop and back up, and I tried to push him off my person several times, but he continued to push and pin me between the door and his person in attempts to escape. I was forced to draw my weapon and point it at him due to his failures to follow verbal orders. After he was in custody, Mr. Hisler stated to my coworker that he did not know we carry weapons and that he would not have tried to get past me if he had known I had a weapon on me. Sadly, I know that Mr. Hisler has a habit of preying on individuals he deems weaker than himself. He has been arrested several times while on parole for assaulting other parolees. During the arrest prior to the incident on July 25th, he made threats against the victims' lives and stated that the officers would be back for a murder charge. Mr. Heiser also wrote a letter to my boss while he was in jail. She received it last week. The letter indicates that I'm lying about what transpired on July 25th. However, Mr. Heiser admitted to his agent that he grabbed my arm and twisted my skin. He admitted that he felt it was okay to put his hands on me because he did not believe I was carrying a weapon. He also pled guilty to the charges he's being sentenced on today. The letter that was written to my boss was volatile and vitriolic. The letter blames me for his actions, showing that Mr. Heiser takes no accountability for the incident on that date. His letter and statement indicates clearly that if Mr. Heiser deems his opponent weak, he has no problem attacking someone physically. Lastly, I would like to address my dismay with the legal system here in Washtenaw County. I was horrified to learn that Mr. Heiser was originally charged with a misdemeanor offense and was given a $1 bond. He only remained in jail due to the parole detainer that was placed on him. One of my coworkers had to reach out to the prosecutor's office to request felony charges that we are here for today. I am grateful that the misdemeanor charges were dismissed and that he was charged with the appropriate felony charge. I'm grateful that I was able to go home to my family on July 25th and every day since. I'm grateful that I physically only suffered bruises and swelling. I'm grateful that drawing my weapon was enough to make Mr. Heiser step back and cease his attack. I am grateful that while this was happening, I was on the phone with my coworker. She could hear what was happening and contacted 911 to come and assist me. This is my first time in court as a victim. I spent years working with victims who felt their experience was minimized. This is why I felt it was important to speak out. If the court should feel it appropriate to sentence Mr. Heiser to a jail sanction, the Department of Corrections will likely return Mr. Heiser to prison for this offense. So after he serves his prison term, he will parole to the county to serve out his sanction for the charges we are here today. I ask the court to keep that in mind. Again, I would like to thank the court for their time and this opportunity.
Thank you for your comments. Ms. Blanche, do you have any comment on the recommended sentence at this time?
Judge, I ask you to follow probation's recommendation at this time.
All right. Mr. Shemke, do you have any comment on the recommended sentence and any allocution on behalf of your client?
Yes, Your Honor. I've been representing Mr. Hisler since February of this year, and I've had an opportunity to see his behavior. I've had an opportunity to see if it's changed over time. I believe that this particular offense, I think that it could have been directly correlated with some substance abuse issues. And I noticed that in the past 128 days since he's been in custody, my client's personality, his view, his circumstances of the future have been altered for the better. Now, obviously, in this stance, I wasn't there, and I can never appreciate anyone being in harm or in fear. But I will note that in this circumstance, after having an opportunity to speak with Mr. Hisler, even as recent today, that he's optimistic about his future and he is not going to duplicate the kind of behavior that has brought him to the circumstance today. When determining what his appropriate admonishment should be, I only ask that you consider that he has done 128 days in custody. I'm aware that he does not get credit for those days because it's on a parole hold, but just to take into consideration my client's age and his possibility of potentially being reunited with his children, his grandchildren, as well as having the opportunity to be gainfully employed through the roof company that he's been at for the last 25 years. I thank you for your time and consideration, Your Honor.
Right. Mr. Heisler or Mr. Hisler, is there anything you wish to say before I impose sentence?
No, go ahead.
Okay.
Wish I could take a polygraph test to prove I'm guilty. I'm not guilty. Good.
Okay. You pled guilty, though, correct?
No, I pled guilty, but if I would take a polygraph test, I would pass in true colors, and she won't. She's lying. But go ahead, sir. Go ahead and do what you got to do. I'm sorry, you never see me again in front of you, though. I know that. She's wrong.
I'm going to just take a second here to think about this. I'll be right back.
We'll be in a brief recess.
Oh. Liar.
Mr. Hisler, while we are off the record, I strongly recommend that you discontinue from the conversation that you're having with the court on this nature. It's not helpful right now, so just relax, but it's not the path to go. No, Mr. Hisler, take my advice with a grain of salt, but take a break, wait for the judge to get back on the record, okay?
Only God take care of it. Wrong, man. They want to salt on my record. I ain't getting nothing back out on parole. I'll do my tail. That's 3 years.
All right, we are back on the record in case number 22582FH. This is the date and time for sentencing in this matter. We have gone through basically in the entire sentencing protocol, gone through the calculation of the sentencing guidelines, all the way through to the defendant's statement to the court, wherein the defendant basically said that the victim is lying. So at this time, I cannot turn a blind eye or a deaf ear, since we're not actually in physical proximity to one another to this. So I am going to reject the plea at this time, and I'm setting this for pretrial next week, and we will see what happens.
Well, Judge, why? I guess you can sentence him however you want to. I don't understand, just because he's saying the victim's lying, he took accountability for it at the time of the plea. It sounds like after the PSI, he has buyer's remorse, which he's not able to withdraw his plea, and the plea is not nullified at this point. So if the court's going to sentence him to prison, which honestly, the fact that Mr. Hisler doesn't want to take any accountability, his attorney said he's changed so much, and now here he is saying that it's the victim's fault, he's not taking accountability. I don't know how he has any right to withdraw his plea, or his plea get withdrawn and nullified at this point. I'm asking you to sentence the defendant. If you want to send him to prison based on the fact that he's not taking accountability, I'm fine with that, Judge. But if we want to adjourn it a week and you think about it, but at this point, I don't know how the plea is nullified based on the fact that now, after he sees the PSI and after the victim's statement, he's trying to say that the victim's a liar.
I mean, I guess in my mind, he is stating on the record, I mean, essentially trying to pave the way for an appeal. Mr. Shemke, we didn't adjourn it, but, has just gone over the PSIR with him. This feels to me a lot like this defendant is seeking some way to cloud this matter for appeal. So, at this point, I guess what I could do is just adjourn the sentencing a week to think about this, but I am not convinced, Ms. Blanche, that perhaps a trial in this matter and having this matter go all the way through isn't a more clean way to achieve whatever is being achieved if he's found guilty. My concern is that based on everything that's before me today, this feels a lot like this is an attempt, to this. So, I mean,
well, Judge,
Ms. Blanche, likewise, if I reject the plea, you're free to appeal that as well. So,
okay.
What I can do is this: I can adjourn the sentence 1 week, and we'll be back here next week to consider this. But I at this time, my inclination is to reject the plea and set this for pretrial. So I'll consider this and your statements for a week, but obviously everybody has the right to appeal me if they don't like what happens. So, okay. So we'll be back here next week.
Would that be December 7th at 1:30, Your Honor?
Correct.
My name's Davenport.
Would it help you to sit down?
Well, I can't. My legs is swelled up. My legs is swelled up by her. I'm handicapped. I was born handicapped, sir. I was born backwards. I'm speaking. Go on, fuck you. I'm not. The shit up here. Yeah, my head too. What you laughing for? Yeah, I won. This what the fuck you laughing for? Yeah, my goddamn head ain't no fucking joke.
By the way, these are broadcast proceedings. If we could calm down with the colorful language, it probably would be more.
Okay, but I ain't said no language. I was been rapping. I was singing my song. I ain't said no language. I would say in my music. I don't trust in my music.
All right. Mr. Davenport, you've been charged with criminal trespass. That would be a Class C misdemeanor if convicted. You understand what you're charged with?
Yeah, Class C trespass.
C,
That's all. That ain't nothing. Yeah, that ain't nothing but a misdemeanor.
correct.
I know the law. I know the judge, the court. I can be a judge in court. What you doing? I can do what you doing too.
Okay. And would you like me to read the allegations?
What's the allegations? There ain't nothing but trespass. It wasn't me. They just framed me as somebody else, but they just ain't me because I'm rich. That's why.
Okay. Well, I'm going to have to set this for court on Monday. So would you like me to appoint an attorney to represent you?
I can be my own judge if I want to.
Tuesday.
Yeah, you can. Okay, yeah, you can put me on.
I'd ask you some questions on oath, make sure you qualify, and or also to set your
I
bonds.
get disability, sir.
Will you raise your right hand and be sworn in?
I got to ask you about that's right. I think I get $841 a month. That's what I get disability, sir.
I need to swear you in, though.
All right, I swear myself in. What's up?
I need to swear you in. You don't swear yourself in.
Okay, well, I can be allowed to judge too. Okay.
Okay, well, raise your right hand and be sworn in.
Yeah, well, I'm a judge
This
too.
is a
I'm
uniform
joking.
affidavit of indigency that you filled out of jail. You swear or affirm that everything you filled out on this form, any testimony you give is true and accurate?
Yes, that's right.
Thank you. You have a job?
I get disability, sir. You understand? I'm handicapped. I was
How much
born
do you get for
backwards, sir.
disability?
Okay, I was born backwards. You understand my life? I was born backwards. My bubble was in my front. I was born backwards. I'm talking about my head. Now, if I hit my head on this not candy floor, what the hell you keep doing it? I hit 17 times on my goddamn head. I'm not with it. Who's doing it? Ain't nothing but devil in there. That's what I'm saying. My head.
Okay, again, if I can't get through arraignments, I'm gonna have to put you off until later. So I just need you to answer the questions that I ask. So how much do you get for disability?
I get $821 a month, sir.
$821?
I get $7,000 a month.
$821?
Yes.
In property, a house or car that you own?
No, I ain't got no house on my nose, but I do got some. I'll let you know. 127. I got 127 properties.
Any other forms of income?
I got 127 properties. Thank God. 127 properties. That's what I got.
What do you think they're worth?
I don't know, about $1 billion. I don't know. I don't know what they were. Probably billion. Billion, billion, trillion. Billion,
Other
trillion,
forms of
trillion.
income or assets?
All right. I don't dare come to this day in there. So what else you talking about? Nothing. I own the judge. I own the courthouse. That's what I'm saying, sir. And you gotta love somebody. You can't hate somebody. You gotta love somebody. Call love that hate. I'm gonna keep what they love. So that's what called love.
You live in Knoxville?
Yes, I do. I live out. I got houses all over now.
How long you lived here?
I'm alive, sir.
You got family here?
Well, I got family here.
Who's that?
But I know, man, Davenport, Cobras.
And is there anybody that would vouch your liability to show up in court?
You know, I'm busy for, I'm the heir, what you call it, I am the heir, sir. That's the question. I am the heir. Because more Davenport, I am the heir from Knoxville. It's my heir, okay? So I don't need no check, I just tell them to send me my money. I don't need no check, just send my heir. Heir born B&B, that's what it is.
Okay, I'm gonna set your bond at $250. I'm gonna set this in court on Tuesday in misdemeanor court for a bond review, so that if you are unable to post the bond, the judge can take it up at that time and reconsider it.
First all, y'all can let me out of the jail free.
That's all I have for you.
Yeah, all right, when you want to get down, sir? Them legs up.